Okay, I'd like to welcome everyone to our 2022 FPSE HRISC Speaker Series event today. I'm going to introduce our co-moderator for this event, David Sadoway. David?
Thanks, Lisa. My name is David Sadoway, and I'm involved with the Human Rights and International Solidarity Committee of the Federation of Post-Secondary Educators. So those are the acronyms, right? HRISC, Human Rights International Solidarity, and the Federation of Post-Secondary Educators. The Federation is over 50 years old, and we have over 10,000 members across what is known as British Columbia. And our members work in union movement, essentially faculty associations in colleges, universities, both public and private sector. And one of the committees of FPSE is the Human Rights International Solidarity Committee. We've been around for a while, and we have something called the Speakers Tour. So before the pandemic, the Speakers Tour would go around to our different member locals all over BC. And we would bring speakers who are talking about human rights issues, that are of interest to members. And because we're a kind of a knowledge-based community, we're also working with our communities and our students as well. So the Speakers Tour has continued virtually this year. And in February, we held our first event. It was a virtual event, as I said, and it was focused on migrant workers in Canada, international migrant workers in Canada. And so talking about their experiences in home countries and then as we talked about their workplaces. This second event tonight is also sharing that same theme, exploitation at home and abroad. And we're focused on mining, Canadian mining in particular. And so all of our guests tonight are going to talk about that in different ways and shapes and forms. I also wanted to give you a little bit more background on the Human Rights International Solidarity Committee. Some of our work you may be aware of, and some you may not be. One of the things that we have is something called the International Solidarity Fund, and it's a small grant fund where we partner with members in local colleges and universities who are doing projects abroad. And so we've supported quite a number of interesting projects over the years. So if you're interested, we've already passed the due date for this year for applications. But if you're interested, talk to one of your local FPSE member colleges or universities, and specifically to their faculty association, and they can tell you more. Another project that the FPSE HRISC has previously been involved in is something called the Manual on Decolonization. And that's accessible. I'll try to put up a link a little later on, actually, but that's accessible through our FPSE website. And that's kind of things that our group supports. So I think actually I jumped too far ahead because I forgot a very important thing, and that is actually acknowledging where I'm transmitting from and where we work and where we live and where we play. Many of us, at least, here in quotes British Columbia. So with this in mind, I wanted to acknowledge that the lands that we are on, the First Nations and the Métis and the Inuit lands, that our offices are located in the unceded and ancestral territories of the Coast Salish peoples, including the Musqueam, the Tsleil-Waututh, and the Squamish First Nations. So we wanted to ask you yourself, wherever you're joining us from, to also take a moment to think about that, to acknowledge that, and that will also be interrelated to the talks that we're hearing tonight as well. So you can, if you want to do that in the chat, you can feel free to do that. Okay, I'm going to pass on the baton then to my co-moderator tonight, and Lisa and I will be kind of interspersing with questions, and we'll also be fielding, bringing in your questions as well. So we would encourage you to use the chat to type in your questions as we proceed. My co-moderator is Lisa David, and she is working at Douglas College. and she's working in criminology, and she's trained as a lawyer. So Lisa, without further ado, I'll pass it on to you.
Thank you, David. I'm going to take this moment to introduce David. David didn't thoroughly introduce himself, and I want him to get the recognition that he deserves. So David Sadoway is the co-moderator, as you know, and he's the professor at Kwantlen Geography and Environmental Department. He's the HRISC representative, just like myself, to the Federation of Post-Secondary Educators. In addition to his studies of urban planning and environmental managing, he's also interested in how people around the globe are working together to address common ecological, socio-economic, technological, and political dilemmas and controversies. So thank you very much, David. I'm going to take this time now to introduce our guests. Thank you, everyone, for attending our Human Rights Speaker Series today on exploitation at home and abroad, with a focus on Canadian mining. Our first guest today is Jeffrey Weber. Jeffrey is a political economist with research interests in Latin America, Marxism, social theory, the history of the left, international development, capitalism and nature, imperialism, the politics of class and social oppression, and social movements. He has co-authored 5 books. He is the co-editor of 2 books, and he is currently working on 3 new books. Jeffrey is currently working at York University, but he has lectured across Europe, North America, and Latin America. So thank you very much for joining us today, Jeffrey. Our next guests are Catherine Nolin and Grahame Russell. Catherine Nolin is a professor and chair of the Department of Geography, Earth and Environmental Sciences at the University of Northern British Columbia in Prince George. Catherine is a social geographer with 2 broad areas of research interests that connect and overlap in many ways: Guatemala, violence, development, justice and migrations, transnationalism, and refugee studies. Catherine is a longtime insurgent researcher and social justice advocate, including more than 25 years grappling with the afterlives of the Guatemalan genocide. In addition to the chair of her department, Catherine is the chair of the Conference of Latin American Geography Organization, or CLAG. CLAG is the premier organization for geographers engaging in research in Latin America and the Caribbean, and the organization works to foster research, education, and service related to Latin American geographical studies. So thank you very much, Catherine, for joining us. Grahame, I'd like to introduce Grahame next. Grahame Russell is a non-practicing lawyer and an adjunct professor at the University of Northern British Columbia in the Department of Geography, Earth and Environmental Sciences. Grahame has over 25 years of experience working on development, human rights, environmental justice, and disaster relief issues in Latin America, mainly Central America and Southern Mexico. Grahame has lived for over 10 years in various countries in Central America and in Southern Mexico. His focus is on human rights. His work includes that of a human rights lawyer, director for a nonprofit development, human rights, disaster relief, and environmental protection organization, Rights Action, educator, and activist. Both Grahame and Catherine have worked together for almost 20 years to organize and facilitate field schools in Guatemala for undergraduate and graduate students. So thank you again, Catherine and Grahame, for joining us today. Our last guest today is Merle Alexander. Merle is a member and hereditary chief of the Kidetsu First Nation on the mid-coast of British Columbia. He practices Indigenous resource law, empowering nations through title and rights affirmation, sustainable economic development, and environmental conservation. In addition to Merle being the principal at the law firm Miller Titterley and Company, he's also the recipient of the Business in Vancouver's Top 40 Under 40 Award, the University of Victoria's Distinguished Alumni Award for Lifetime Contributions in Law, and he received the honorable designation of Queen's Counsel, one of the few Indigenous practitioners in Canada to ever receive the designation. Merle is also recognized by Lexpert in Aboriginal Energy and the Mining Law of Chambers Canada. He has extensive experience in negotiating government-to-government agreements in BC and the Yukon. A legal passion of Merle's is the protection of Indigenous intellectual property rights, particularly traditional knowledge. He has negotiated treaty chapters on heritage resources, drafted protocols, represented national Aboriginal organizations in various UN forums. He is considered to be an international expert on protective mechanisms of Indigenous knowledge. Thank you very much, Merle, for joining us here today. I'm just going to give a very brief overview of the panel discussion. So as you know, we're here to speak about Canadian mining exploitation, both abroad and at home. We're going to speak first to the issue of Canadian mining abroad, and then we will turn our attention to Canadian mining at home in Canada with a specific focus of mining in BC. Our guests, Jeffrey Weber, Catherine Nolin, and Grahame Russell, will be focusing on Canadian mining abroad, and Merle Alexander will be focusing on Canadian mining in Canada, specifically in BC. So turning to the first part, Canadian mining abroad, just a brief introduction. Canada is home to 75% of the world's mining companies. Firms based or listed in Canada operate approximately 4,000 mineral projects abroad, and many of these projects involve corporate practices that violate human rights. There have been an astounding number of conflicts at Canadian-run mines, and these mines have caused environmental devastation, have led to violent confrontations. All over the world, Canadian-run mines habitually destroy farmland, harm endangered species, and contaminate drinking water. The mining firms are also responsible for beatings, kidnappings, arbitrary arrests, and killings in local communities. They frequently undermine Indigenous self-determination as national and regional governments give them permission to operate in spite of overwhelming local opposition. Over the past 2 decades, reports, documentaries, books have all detailed Canadian mining abuse abroad. And one of these books is Catherine and Grahame's book, Testimonio. It addresses Canadian mining in the aftermath of genocides in Guatemala. Another one of these books is The Blood of Extraction, Canadian Imperialism in Latin America, co-authored by Jeffrey Weber. I'm going to turn to Jeffrey Weber, who will speak on the issue of Canadian mining abroad. I'm just going to give a very brief overview of his book, Blood of Extraction. It examines the presence of Canadian mining companies in Latin America and the environmental and human rights abuses that have occurred as a result. Jeffrey illustrates the myriad ways Canadian-based multinational corporations backed by the Canadian state have developed extensive economic interests in Latin America over the last 2 decades at the expense of Latin American people and the environment. Latin American communities affected by Canadian resources extraction are now organized into hundreds of opposition movements from Mexico to Argentina. And Jeffrey has been able to illustrate the strategies used by the Canadian state to silence this resistance and advance corporate interests. Jeffrey, if you could please share with us the insights your work has provided you on Canadian mining abroad and the human rights toll it has taken on workers and the Canadian state's complicit role it has played in propping up Canada's predatory mining industry. Jeffrey.
Thank you very much for that introduction, and thanks also for the invitation to speak this evening. It's a real privilege to speak to all of you, everyone who's here, and also to share the space with my esteemed co-panelists. My comments today will draw mainly, as Lisa was suggesting, on the co-authored book, Blood of Extraction, that I put together with the Canadian political economist and friend of mine, Todd Gordon. And for that book, we dissected thousands of pages of mining industry publications, access to information documents from various departments of the Canadian state, and conducted dozens of interviews with peasants, indigenous people, workers, ecological activists, lawyers, human rights defenders, and so on throughout Central America and the Andes. And what I want to do with my time is to step back slightly from immediate events and to give a kind of broader bird's eye perspective on the expansion of Canadian mining capital in Latin America over the last several decades, really ticking up since the 1990s in a dramatic way, as well as the diplomatic, security, and geopolitical role of the Canadian state in promoting and defending the interests of Canadian mining corporations in Latin America over this period. So obviously this is going to be a kind of cursory, broad sweep. I'm happy to talk more about details, but they will also be enriched by the subsequent presentations. What should become obvious, I think, over the course of my remarks is that the Canadian state prioritizes defending the profitability of Canadian mining capital abroad over any other concern in its foreign policy in Latin America, whether it be indigenous or peasant dispossession and displacement, ecological devastation, or human rights abuses. Those concerns are very much secondary, in fact, can be totally overridden by the interests of Canadian mining profitability. My argument is that we need to step back from only looking at this or that Canadian company and its abuses, as important as that work is in individual struggles, in order to identify the structural systemic pattern of behavior and the consistent role of the Canadian state in promoting and defending that. And this is true in the last several decades, whether the Canadian state was governed by conservatives or whether it was governed by liberals. The orientation has been promoting the interests of Canadian mining capital and defending the often deplorable activities of these companies that they find necessary to pursue in the ultimate pursuit of profit. Overwhelming evidence has now mounted in the literature on extractive industries in Latin America over the last 2 decades, which shows the serious adverse environmental and cultural impacts of capitalist extractivism. The social science literature on the topic shows clearly that communities that enter into resistance to multinational mining corporations face death threats, criminalization, intimidation, harassment, and worse. In our book, we document all of these patterns systematically in a specific association with Canadian mining capital. And by Canadian mining capital, we mean capital that has a clear and identifiable Canadian owner, whether as an owner of a private company or as a majority or controlling influence minority shareholder of a publicly traded company. I think the best framework to understand this dynamic is to position Canada's political economy within the global processes of capitalist accumulation and to understand Canada's role therein as a secondary imperialist power. Within this kind of framework, the story becomes much less about this or that bad apple as a Canadian corporation, and rather focuses our attention on the much bigger scale of change required to end the human rights abuses and ecological devastation associated with Canadian mining activity in Latin America. Just to set the stage, in recent years, the Canadian state has lent its support to a repressive post-coup regime in Honduras. It has provided military and ideological backing for a repressive regime in Colombia. It has aggressively interfered in domestic affairs of left of center governments in South America. It has supported ecological destruction and the dislocation of vulnerable populations in the region through its support for Canadian natural resource companies. And it has sought to delegitimize, to co-opt or coerce popular movements that have directly challenged the economic interests of Canadian mining capital. The point is that these are not isolated or extreme instances, but rather the dominant trends of Canadian foreign policy in Latin America. Canadian multinational corporations that are Canadian corporations based in Canada that have operations abroad have expanded rapidly into Latin America as a whole since the 1990s, with routinely devastating impacts on human rights and the environment in the mining sector, especially, but not exclusively. This explains why the expansion of Canadian capital since the 1990s in Latin America has gone hand in hand with waves of creative and militant community resistance, which has proved the most successful way thus far of containing, to the extent that it's been possible, the most predatory behavior of Canadian capital and the Canadian state's policies that abet Canadian capital's operations in the region. The expansion of Canadian mining capital in Latin America is inseparable, I want to argue, from a more outwardly aggressive Canadian foreign policy and the effort of the Canadian state to imprint itself on the decision-making of Latin American states and communities. In geopolitical terms, Canada has been interested in containing through persuasion and or eliminating through coercion the rising tide of popular social movements and left-leaning governments in the region. Crucially, these movements over the last few decades and the center-left governments and left governments that have sometimes come to office have largely grounded their legitimacy in efforts to reclaim popular sovereign control over natural resources and to reassert political and economic autonomy in the region vis-a-vis dominant external powers, not least from Canada in the mining sector. This was rightfully seen by a series of Canadian governments beginning in the 21st century, especially as a threat to the profitability of Canadian mining investments, and they've done everything possible to thwart the possibilities of these social movements and center-left and left governments. Now, the scale of the expansion of Canadian capital in Latin America in the form of foreign direct investment over the last 3 decades has been phenomenal. Following the liberalization of capital flows in Latin America, as well as the rewriting of natural resources and financial sector rules and the privatization of what had been public assets in the region, beginning with the turn to neoliberal restructuring and structural adjustment policies of the 1980s and 1990s in the region. This really opened up a window for Canadian private investment in the region, and Canadian mining investment in particular is a big part of this overarching uptick in Canadian investment in Latin America over the last few decades. Canada's mining industry, as was mentioned in the introduction, is the largest in the world. Approximately 2/3 of the world's mining companies are based in Canada, with its permissive tax and legal regime, long mining history that has nurtured an aggressive exploration and producing sector, and unflinching foreign policy support for companies with international ambitions. Those international ambitions, coupled with the Canadian state's legal and diplomatic loyalty to the industry, has led Canadian companies, big and small, to the 4 corners of the globe in pursuit of profit. This is, of course, especially the case in periods of commodities boom, when prices are high, as they were in particular in the 2003-2013 period in the Latin American context. So in that broad pursuit of profitability, Latin America and the Caribbean account on their own for over half of Canadian mining assets held abroad. According to the Northern Miner, which is an industry web publication for the mining industry, according to one of their databases, in 2014, 62% of all producing mines in the region were owned by a company headquartered in Canada. The size and international leading role of the Canadian mining industry is no doubt the reason Toronto is the most important financial nodal point of the global mining industry. In 2013, for example, $69.5 billion Canadian was raised in equity financing on the city's 2 exchanges, the Toronto Stock Exchange and the Toronto Venture, representing 84% of the total. The dominance of Latin America's natural resource markets has showered the owners of Canadian companies with massive profits, and we go systematically through these in the book. But just looking for a moment at the earnings from gold mines that were still operational in 2013, for example, 15 gold mines in total, the 3 largest gold mining companies by revenue, which were Barrick, Yamana, and Goldcorp, earned a combined net profit of $14.9 billion US between 1998 and 2013. Now here, presented plainly, is what typically meant by Canadian governments when they speak of Canadian interests abroad in Latin America. The argument of Canadian governments of various stripes, as well as the argument of the companies themselves, is that Canadian resource companies are not simply getting rich off the resources of impoverished and dispossessed communities, but are instead improving the living standards of the communities where they are digging gold, silver, copper, and other minerals from the ground. In truth, very little of the company profits are reinvested in local communities. Barrick and Yamana's combined community investment spending part of the company's corporate social responsibility agenda to create the fiction that they give back to communities was a miserly 1.4% of net earnings in 2012 and 0.9% in 2011. But beyond the supposed community investments of corporate social responsibility, after the construction phase of mining is completed, there is very little new inflow of money from these companies into the countries in which they are operating mines. And the construction costs of new mines are usually made back within the first few years of the mine's operations. Most of their profits, in other words, leave the country, and after the construction period, mining represents a significant net outflow of value. It is important to keep in mind as well how poor a job creator large-scale industrial mining is, on top of the human displacement and irreparable ecological damage these mines by necessity cause. For example, according to the UN Economic Commission for Latin America and the Caribbean, mining and oil investment together are the lowest job creator out of the 12 major industries featured in the relevant UN Economic Commission database, with only 0.5 jobs created per US $1 million invested. Canadian capital's penetration of Latin America, moreover, has not been accomplished on its own. It has received the steadfast support of the Canadian state. From the Prime Minister's office to Foreign Affairs, the Canadian International Development Agency, as of 2015, Foreign Affairs, CEDA, and International Trade are all now part of Global Affairs Canada. National Defense, Natural Resources Canada, and even Health Canada. We observed in our access to information documents are all coordinated in their effort to legitimate and defend the expansion and supposedly good behavior and best practices of Canadian mining corporations abroad. Canadian foreign policy in Latin America has been intimately bound up with the outward expansion of Canadian mining capital, both responding to the imperatives and shaping the actions of Canadian multinational mining capital, as their investment in the region has steadily grown and encountered various political and social obstacles in the form of community resistance and in the form of even tepid center-left attempts to regain some national autonomy over resource administration. All of this is underpinned by a network of Canadian embassies throughout Latin America. As was made clear in our book, Blood of Extraction, embassy staff, that is ambassadors, trade commissioners, CEDA agents, are the frontline missionaries of the Canadian Imperial Project vis-a-vis mining in Latin America. From applying various kinds of diplomatic pressures on governments to being the eyes and ears and mouthpieces for companies in Ottawa abroad, embassy officials play a crucial role in intelligence gathering and policy implementation. They often assume a behind-the-scenes role as facilitators for Canadian investors. So I could go much more into the detail of all of the different instances, but what I wanted to do in these opening remarks is simply to lay out a certain logic to the pattern of Canadian mining capital expansion and the associated expansion of an increasingly interventionist Canadian foreign policy on behalf of and in the interest structurally of Canadian mining capital profitability abroad, so that it shouldn't be surprising when there is this or that violation of human rights or ecological ruin or any other displacement, dispossession, assassination, repression, and so on associated with these activities, but rather to see it as a logic flowing out of and what we ought to expect from the patterns of the Canadian state vis-a-vis its relationship to Canadian mining capital abroad. And therefore, seen in this light, it's not that it's unimportant to wage specific battles against specific companies. Of course, that's necessary legally and through extra parliamentary forms of resistance. But we ought to step back occasionally to see beyond the patterns of individual corporate behaviors to show that this is a structural phenomenon, and therefore a necessary response is going to have to be on a scale fit to that purpose, fit to the scale of the problem we face. And I think we need to have our eyes open when we speak about alternatives on that scale. Thanks very much.
Thank you so much, Jeffrey, for that wonderful overview of the structural systemic pattern of behavior by the Canadian state to support the mining industry abroad. I'm just going to remind everybody here tonight that you can feel free to post your questions if you like in the Q&A portion of the event. Feel free to type them in and we can put them directly to our expert panel. I have a question, and David, if you have any questions. One question I was curious, and I have several questions, but you talk, Jeffrey, about not bad apples, but the whole system itself is structured this way. And maybe this is too big of a question. I could save it for near the end, but you talk about that we still have to have a multifaceted approach and use our regulations and our courts. Is there a way that we can address this, because it is such a larger, it's not necessarily like you talk about just the one bad apple? How is the best way to make the needed changes?
So that's a great question, obviously a massive one that I don't pretend to have a kind of the finished answer on. But what I would say in terms of broad observations is that while the legal pursuit of rights is a necessary facet of what's available and ought to be used strategically where necessary, it's also the case, I think, that the most successful, although partial, containment of the worst behaviors has been through often illegal and repressed community resistance. I mean, made illegal by, for example, in Ecuador, blocking a road became a terrorist offense under anti-terror legislation, right? So within the boundaries of the law, you couldn't even block a road to prevent a Canadian corporation from accessing its site. Well, in those instances, the law needs to be broken, as it was repeatedly and successfully by very courageous Indigenous resistance, who appealed, of course, to other laws, the international law, to consultation, which they argued wasn't actually being observed by the Ecuadorian state or the Canadian companies that were operative. So I would say that even on the, structurally massive changes are necessary, but of course, my point is not that we wait until some kind of magic moment of structural change, but that even reforms are much more likely, it seems, based on the evidence, to come from mass organizing and mass-based militant resistance, which works with the law when and until it can, but is not restrained by. And this is true, I think, as well, of the most successful dynamics in the Canadian state, historically in opposition to Canadian mining interests, because the legal apparatus is designed not to win, in my view. It's designed to absorb and to contain and to professionalize and legalize resistance, which can take years and years and years, and channel resources of communities towards that kind of struggle, which can often be futile. So I'm not saying that this is a resolute idea against that, but I'm saying that the most inspiring forms of resistance have depended on the strength of communities themselves, which sometimes has required confrontation with the state, which is acting on behalf of capital.
Yeah, I understand you're saying that the legal avenue is really addressing that one bad apple at a time, almost, as opposed to the larger structural issues. It has a much more difficult time addressing these issues, if at all. So yes. David, do you have any questions for Jeffrey?
Yeah, I have one question, and then maybe we can move on to the next panelist, and I'm sure there'll be some more questions in the chat. And I would also just reiterate to our audience, who it sounds like we have an audience of people who some who are quite aware of mining industries. So I would encourage you to also type in questions, and we can also ask them at in the next round, so to speak. Yeah, Jeffrey, thanks for your presentation. And I still haven't had a chance. I was hoping to do it before the panel to get into some of your books, but I noticed that one of your 5 books is focused on Bolivia. And so that prompted me to think about kind of this shift right now. I mean, with the Ukraine invasion, we understand that the world price of nickel has now soared, right? Because Russia has apparently 1/3 of the reserves of nickel, and nickel is being used in EV batteries, right? And then this raises the whole issue of so-called rare earth minerals. So my question was, and it's pre-concocted, so I'm just going to read it. The role of big tech is increasingly playing an important role in mining, whether in the search and mining for rare earth minerals or Bitcoin mining, certainly, which is not a form of traditional mining. But in his quest for access to rare earth minerals for vehicle batteries, the big tech titan Elon Musk has publicly critiqued, and I would also add probably the richest man in the world, has publicly critiqued the governance of Evo Morales, the former leader in Bolivia, indigenous leader as well. And in your view, what role does big tech play in shaping or reshaping the changing terrain of mineral extraction in Bolivia? And then I suppose we can extend that to Canada and beyond. That's the first part of the question. And then I'm gonna be like my colleague and ask you sort of the meta question as well. How can Indigenous peoples and government, and I don't want to presuppose that you could speak on behalf of Indigenous peoples, but from your observations, particularly in relation to Bolivia, how can Indigenous peoples and governments and communities in particular better respond to the seemingly insatiable demands that we're now seeing for rare earth and other minerals like nickel? And I should add, I was born in a nickel mining town, and we had to relocate because my mom was impacted. She became asthmatic because of the impacts of the nickel mines smelter. So nickel is of interest, right, for sure.
Right. So that's I mean, those are great questions, and I will restrain myself massively from just going on for too long in response, which one could do. So I'll just try and say very impressionistic first go. I think what you're getting at with big tech is part of the question of the green capitalism's attempt to transition to a kind of a post-fossil fuel future, which of course, I mean, they're not actually transitioning to a post-fossil fuel future, but they're making gestures towards new lithium being a massive source for example, all of the batteries that go into that would go into electric cars or electrification of any sort. And so the idea there is a solution that that is aimed to allow for the profits of so-called green companies to expand. Now there might be a way. I mean, clearly we need to extraction of resources is not per se. I mean, we need to extract resources in the sense that we have some kind of metabolic relation with non-human nature in order to live, right? So the extraction of resources is not a problem per se. The extraction of resources for profit is a problem because all other considerations of meeting human needs and meeting environmental sustainability are subordinated to the profit motive. And so lithium, although it might be extracted for the supposed purpose of a transition away from fossil fuels, insofar as it's driven without a change in social relations and property relations and so on and so forth, is going to reproduce the same pattern of conflict and out solving the problem of ecology that it's meant to. That hardly answers the question, but lithium is the big center in which this is going to play out in Bolivia and in Chile, in neighboring Chile on these questions. And on indigenous struggle in Bolivia, I think I don't have much time to defend this position, but I'll just say it as an assertion and undefended, and maybe defend it in discussion, is that I think we need to distinguish. Sometimes it's I'm not saying you are doing this, but sometimes it's talked about as if Evo Morales were an expression, an unproblematic expression of indigenous interests in Bolivia, where I think although he came to power on the wave of a left indigenous mobilization, a series of mobilization, he was constrained in his administration of the state, often pursuing the interests of agro-industrial capital, deals with mining companies that were resisted by indigenous communities, resisting the first indigenous president who was ruling the capitalist state of Bolivia. Right now, we can argue about whether he had any other alternative or so on. But the most important gains that were made in Bolivia, I would say, even during the Morales period, were not from kind of benevolent legislation from the government, but rather from the dogged, whether it was with the government or against it, the dogged face-to-face confrontation with the expansion of extractive capital, whether that was endorsed by the government or whether it wasn't. And I think that's the big lesson to be drawn, is these kind of self-activity and self-organized community self-determination, which sometimes doesn't find an easy one-to-one reflection, even in a progressive government. There's a lot more to say, but others have to talk after me, so I'll stop.
Thanks for the insights.
Thanks, Jeffrey. We do have a few minutes, and I do want to get to an audience member. Micah has asked in the questions, can Jeffrey talk more about examples and possibilities for collaboration between activist groups that oppose Canadian mining in Latin America? It says, it strikes me that in the same way that Canadian mining benefits from, oh, it's gone. Oh, there it is. Benefits from its vast transnational networks, grassroots resistance benefits from a unified front. If you could speak briefly to that, Jeffrey, that'd be great.
Sure. I think Grahame and Catherine, who are speaking next, have sort of exemplified some of the ways in which this can be done through their own networks. And in Central America in particular, you can point to, in addition to their activities, which I'll let them talk about, Mining Watch has been an important NGO in Canada trying to make links with Indigenous and peasant and worker resistance to Canadian mining capital, in terms of providing both on the ground reportage, but also attempting to influence Canadian social movements and pressures on the Canadian state and Canadian mining industry at home. And one of the things that they've done, I think, I mean, they're not the only organization to be doing this, and I'm not affiliated. This isn't a conflict of interest. The Mining Watch, what they've done, I think, has shown how these are just connected by in a hypothetical way, but the Canadian mining industry is only properly understood as the same industry abroad as it is at home. This is a singular network of accumulation strategies that dispossess people inside of the Canadian state and dispossess people abroad in systematic ways. And the Canadian state, in articulating the interests of Canadian mining capital, is performing the same role at home as it is abroad. So I think in doing this, one of the things that becomes clear is that activists in Canada need to start to develop an understanding which is systematic, that characterizes the Canadian state as a secondary imperial power abroad and as a settler colonial capitalist state inside of its own internal relations, and to make these connections. Because as you go abroad, and they can do this by learning some of what resistance in Central America and the Andes and in the rest of South America have understood more clearly, I think, in some ways than some patterns of resistance at home is a very clear understanding that the Canadian state is acting in the interests of capital, and the notions of corporate social responsibility and the notions of other sort of benevolent ends of Canadian foreign policy really don't fly on the ground there in the ways that they sometimes do in popular understanding within Canada of if, you know, the notion that if Canada does something bad abroad, it's usually because the American state basically told the Canadian state to do it. Rather, the explanation for why we do bad things abroad has everything to do with our own fully developed capitalist class, fully developed expansionary interests, and the Canadian state's structural interest in fundamentally representing them above all other needs. So in doing that, it identifies who we need to struggle against, both abroad and at home, and see these projects as shared. Sorry, I can't say more practical things. The people who are following, I think, will give much more practical examples from their own experiences.
Excellent. Thank you so much, Jeffrey. And it's a great segue to our next guests, Catherine and Grahame. Just like Jeffrey was describing, he has a much more broader structural view of the mining industry abroad, and Catherine and Grahame are going to be able to give us a more specific understanding of a very specific issue. So they're going to be discussing their book, Testimonio, Canadian Mining in the Aftermath of Genocides in Guatemala. Catherine and Grahame drew on their years of community-based research and direct community support work in Guatemala to expose the ruthless state machinery that benefits the Canadian mining industry. The book includes a series of testimonies authored by Indigenous community leaders in Guatemala and includes contributions from investigative journalists, scholars, lawyers, activists, and documentarians on the ground. And Catherine and Grahame's edited volume tells the horrific story of Canadian mining in Guatemala through the voices of some of the people most affected by the impact of mining at the community level. So if I can get both Catherine first to speak to the issues that you're outlining in your book and discuss the implications generally of Canadian mining abroad, and we'll speak with Catherine first. Thank you so much, Catherine.
Great, thank you so much. It's wonderful to be with all of you, and I'm going to speak first, and then Grahame and I are sharing our time, so I'll turn it over to him to really lay out the key arguments of the book, but I'll kick us off. First of all, I wanted to acknowledge that I'm here in Prince George, coming to you from University of Northern BC, which is on the traditional and unceded territory of the Kwantlen Tenay, and as always, I want to take the opportunity to share my respect for the Maya and Xinca peoples and their territories where we work in Guatemala. And I do think it's important that we do this as our work is done in solidarity and particularly with Grahame, with direct community support of Indigenous land and water defenders, community members who have been and continue to be criminalized, attacked, imprisoned, disrespected, raped, killed, and so on for their resistance to this imposed development, so-called development, and the violence used to implement it. And so we have worked for all of these years in solidarity to work for justice and accountability for the crimes and violations that they and we have documented. I want to thank you for the invitation to be here and join on this panel, and I want to thank Dr. Weber for offering that master class attached to the book. That was really inspirational for Grahame and I as we were pulling our book together. I'm so glad that you're here today. It has been really important for us as we were working on other issues after, and I'll explain a little bit about the genocides that took place in Guatemala and the timelines, but we were working on many other issues with individuals and communities in Guatemala kind of post-genocide. And it was, once Canadian mining company Inco was kind of coming back on the scene to potentially renew their concession to a vast tract of land, that the mining issue came on our radar. And so this issue kind of came to us, but it's so interwoven with so many issues of living after genocide in Guatemala. I want to make mention, I think Jeffrey's argument is so helpful for us in seeing the interconnections really throughout the Americas and beyond, connected to the Canadian state, and the way Canadian businesses work and are connected with a series of genocidal generals, politicians, corrupt politicians, a small but powerful group of oligarchs in the Guatemalan countrysides and in the cities. And I think that's so powerful. And as a geographer, I think we try and connect the scales of experience and accountability. And so for me, I think it's important that we also talk about, the way in which all of this plays out in people's individual bodies, in their communities and their lands, to connecting to the players in the Guatemalan state and so on, all the way up to tying this to Canadian foreign policy. So we can begin to understand in many ways what the Canadian government calls its extractives approach to development. And so I just want to make brief mention of the woman who's on the cover of our book, Deodora Hernandez, who refused to sell her land to Goldcorp, which is a Vancouver-based company. Her land was adjacent to their property, refused, and was shot directly in the face. The bullet went through her eye and out her ear, and she survived. And here she is on her land, still resisting and refusing to leave her land. And so our book really does try and tie these different scales together using a variety of methods and voices to tell this story. That unfortunately, I think it's still surprising and shocking for many Canadians to know what's going on. So I think having Deodora on here was extremely important. So our book, Testimonio, Canadian Mining in the Aftermath of Genocide, focuses on 4 illustrative cases tied to 4 main mining struggles in the country, illustrating what we would call, transnational plunder, the way in which, predatory exploitation of these mineral resources has played out over the course of, we can go back a very long time, but in the coverage of our book from about 2004 until 2021. The Merle mine, which is now closed, that's was a Vancouver-based Goldcorp that ran the Merle mine. The Phoenix project was run by a series of Canadian mining companies, Inco from the 1960s, through Sky Resources, Hudbay Minerals, and now is owned by Solway, which is a Swiss-based but Russian-operated nickel mine. The issues on the ground there today are extremely, extremely tough. The Escobal mine was run by Tahoe Resources and now by Pan American Silver, both out of Vancouver. And La Puya is a struggle that was blocking a mine that was run originally by Canadian Radius Gold and now owned by an American company. But we tried to use these 4 illustrative cases and the voices of many people to bring this story, a series of stories to the forefront and tie to exactly what Jeffrey was sharing with us. So we wanted to be very clear in the case of Guatemala. We're working in a country, and these Canadian mining companies are operating in a country that is still in the recovery phase of extreme state violence, and that reached in the late 1980s and late 1970s and early 1980s reach the level of genocide against the Indigenous people of the country. These are the covers of two documents that emerged at the end of the 1990s. One, Guatemala Never Again, was the work of the Human Rights Office tied to the Catholic Church in the country. And they turned over all of their findings to the United Nations run Truth Commission. On the green cover there, a series of volumes that documented the massive crimes that took place, both the historical context going back 500 years to what was happening in the 1970s, 80s, and into the 90s. And one thing we wanted to make clear is that in these documents, it was designated that genocide took place in 4 different parts of the country, 4 Indigenous regions of the country. And so when Canadian mining companies started operating, we can see that they were operating and starting to make requests for, reconnaissance, for exploration, exploitation, and so on, in the very regions where people were still grappling with the massive displacements within the country, more than 1 million people displaced within the country, 1 million beyond the country, people killed and disappeared, death squads operating in cities and countrysides, and massacres that took place across the country, more than 400 documented. So this map, I think, is quite useful to show that overlap of, Indigenous territories in the country, and then all of these, different colored dots are all and this is quite a long time ago, a map that was shared with us when we first started looking into this. We could probably, quadruple this now. The attempt to get at the land beneath the feet of people who survived the genocides. And so what we might call, or what is called in Guatemala, the 4th invasion, the suits that are arriving to make deals with, the genocidal generals who have still not been held accountable for the crimes of the war and major war crimes and genocide. These are the very people that they're making deals with knowingly. It's not like this is not known. So I think the link is extremely important to highlight here in our work. And as was mentioned in the introduction of the book, we are co-authors of several sections in the book, but co-editors. What we really wanted to do was bring together the work of so many individuals and organizations and people who we've had, the great experience of working with over these last so many years, to bring their work that does a deep dive into each one of these struggles, or the very people who are leading these struggles. We wanted to bring those voices together to create, I think, what is quite a powerful book that sheds light on these range of experiences. We did a presentation last week, and one of the Maya scholars who works on the extractive industry in Guatemala, his name is Giovanni Batz, gave us the great compliment of saying that reading the book and reading all of these collaborators' contributions and those who provided their testimonios, that it was like listening to a marimba in Guatemala, the instrument that many people play together to express themselves and is so central to the life of Indigenous communities in Guatemala. And I did appreciate that so much, because it really is an attempt to kind of overlap from various perspectives, this experience of the 4th invasion in the country. And we really tried to do this by in lots of different ways, from working with our undergraduate and graduate students on delegations, Grahame with Rights Action, working in direct community support with many of the communities that are at the forefront, well, all of them who are at the forefront of these struggles, and running his own Rights Action delegations, but really basically meeting people where they are, getting out onto the land with them, being in community with them, and amplifying their voices through this and other venues. And we were really fortunate to have many people join us who, beyond academics and journalists and so on, but documentary photographer, artists, filmmakers, and so on, who made contributions. So Testimonio, that reflection of more than just your individual experience of the trauma of mining your community, but also the various ways that people can express this. I'll turn it over to Grahame now, because I'd really like Grahame to talk about the key arguments of the book. I think one thing we came away from is this statement, though, that it is not possible to operate a large-scale mine or really any of the other large-scale economic so-called development projects without participating and benefiting from human rights violations and repression, without participating and benefiting from corruption and impunity. That these are not, and Grahame will expand on this, these are not Guatemalan issues, these are Canadian issues. And this book is in a way really directed to Canadians, not so much Guatemalans who know this story well. And for this, there is a long story of the publication of this book that we can maybe talk about later, but our first publisher dropped it when some third party threatened to sue them if they published the book. But with the assistance of a lot of people, including Canadian Association of University Teachers, they funded a libel review, a full libel review, so that the group Between the Lines was able to confidently publish the book. And so we're really grateful that this book has been now published in Canada, in, as Jeffrey says, really the home of mining capital around the world. So Grahame, I'll turn it over to you.
Thank you very much. And thanks for putting this event together, folks at FPSE. And then I'm going to be quite brief because it's starting to get repetitive. I'm going to be repeating some of the major arguments, or giving sort of voice to some of the major arguments Jeffrey said, which I agree with fully, and then just picking up on Catherine's comments. I would say that I approach this work in Testimonio and all the work that's set out in the book like Testimonio fundamentally through my work with Rights Action that's been working in Guatemala since the mid-90s. And Rights Action does two main things and that are particularly relevant to these four mining resistance struggles that are set out in the book Testimonio. We directly fund grassroots struggles, and grassroots struggles meaning human rights defense struggles, land defense struggles, environmental defense struggles, justice struggles. And the four resistance struggles set out in Testimonio are examples of all the above. So we're a direct grassroots funder of these struggles. And then the other side of our work is education and activism, and it's all focused at shining a light on Canadian and US government policies and actions, and then Canadian US companies and investors and their actions. Thus, Testimonio becomes a perfect example of the marriage between Canadian government interests and actions and then the Canadian private sector, mainly Canadian private sector, companies and investors and their actions. And then we also look at very critically in the same way through education and activism, the role of other so-called international actors such as the World Bank, Inter-American Development Bank, et cetera, because they're all, our argument to our supporters in Canada and the US is that we are part of the problem. And then in our government policies, our private sector policies, our investment policies, through to institutions that are controlled by the wealthy countries like World Bank, Inter-American Development Bank, et cetera. And if we're concerned about these issues, then we need to look closely at ourselves and hold ourselves accountable and bring about change in the North, the global North. And Rights Actions works mainly focused on Honduras and Guatemala, and then focusing on Canada and the US. Testimonio sets out, and Catherine's already talked about some of this stuff, sets out both the historic and current political, social, economic context in which the Canadian mining industry, supported by our government, are choosing to do business. And this context is well known. And I'm going to make some generalizations, but Guatemala is a fundamentally undemocratic country. And the book, all the different voices in the book give different examples of all of this list of characteristics: lack of democracy, historic and endemic exploitation resulting in poverty and extreme poverty, endemic racism, historic and ongoing, endemic repression used by both the government and private sector, historically and ongoing today, corruption and organized crime that has infiltrated most of the institutions of the state and the government, including the judiciary, all branches of government, police and military, and then a fundamental lack of rule of law, like the rule of law, that the legal system fundamentally doesn't work to address these very serious issues that a book like Testimonio exposes, which results in impunity for governments and powerful economic and investor actors. Testimony goes on and through all the different voices in testimony to describe the comprehensive overlapping problems caused by mining. Jeffrey's already talked about this, Catherine's talked about this, but the acquiring of it goes through a list of acquiring of questionable, if not outright licenses to operate the mines with no questions asked. And then once the so-called license has been acquired, the mining operation in the 4 regions of the country is imposed through coercion or violence. And that's systemic. And then the resistance of the woman on the cover, Diodora Hernandez, is just one example of that. Someone who stood up and said, no, you can't coerce me or force me to sell you my land. Boom, they sent out 2 men with the intention of assassinating her. And somehow she miraculously survived and lives on her land today. And when the mining company comes to town, usually with a piece of paper saying we're the rightful owners of this land that they've acquired from a judge or the municipal office, they all label the local population for the most part as illegal squatters. And that's why they must be forcibly removed. From there, you get to environmental harm. So in most of the struggles, once the mine starts to operate, widespread water contamination, widespread water depletion, deforestation, air pollution, all of which leads directly to serious health harms and death caused to human life and animal life. And these are agricultural communities that depend on mostly operating at a subsistence level and depending on the few animals they might have to survive. All of this is brought together by human rights violations and violence, killings, shootings, rapes against community defenders. As soon as people stand up and say no, repression comes from the company itself, from the Guatemalan government, and usually by combined forces from both. And to summarize all this, one of the highlighted articles is that of Sandra Cuff, which opens up chapter 2. Her article is titled, it's quite a comprehensive article. It's titled Mining in the Guatemala Mafia State. Sandra Cuff opens her article saying, quote, a military coup clears the way for mining interests. Exploitation licenses are granted by military rulers. A mining company is directly involved in attacks and assassinations. A mining law is written by future mining company personnel. Exploitation licenses are granted by corrupt government officials. A transnational mining executive becomes a fugitive. Company and government officials coordinate police and military action to quell dissent. People's homes are burnt to the ground. People are killed. The history of mining in Guatemala over the past 60 years is one of violence, corruption, and impunity. It is a history of transnational mining companies doing whatever they need to do in order to advance their interests, working with every government administration along the way, whether with genocidal military rulers or administrations so corrupt that most of the top officials are now sitting in prison cells. Sandra concludes her summary saying this is not an exaggeration, and it's not. And her article and all of the voices in Testimonio prove it with example after example. In the introduction to chapter 2, Catherine already showed this quote, but it bears repetition because this is what Canadian government knows. It's what the World Bank knows. It's what the US government knows. It's what the Swiss government knows today. In Guatemala, because of the conditions that I described that come from the genocides of the past and then the ongoing conditions of today, in Guatemala, it's not possible to operate a large-scale mine without participating in and benefiting from human rights violations and repression, corruption, and impunity. Put another way, violating human rights, using repression, and acting with corruption and impunity are how businesses operate in Guatemala, particularly large-scale businesses. Then in our introduction, Catherine and I set out another main conclusion. The underlying problem, one of the underlying problems in all these cases is that the Canadian government and our companies are choosing to do business in the racist exploitative, repressive conditions of Guatemala, wherein corruption, impunity, and a fundamental lack of democracy are the norm. In fact, the Canadian government and mining companies are contributing to and benefiting from racism, exploitation, the repression, corruption, impunity, and the lack of democracy. Kind of a heavy-hitting conclusion, but we do think it's the only logical conclusion that one can arrive after doing this work. And I think that these types of examples would be borne out by the type of work that Jeffrey Weber's been doing for years and sets out in his own writing. So then a main takeaway from testimony, and I think for a Canadian audience and for concerned Canadian funders, donors, politicians, media, et cetera, is that we fundamentally need to reframe these issues, and that these, and Catherine's already alluded to this, these are not, all the issues set out in Testimonio, they're not fundamentally Guatemalan problems, they are Canadian problems, perhaps predominantly Canadian problems, and most all of the harms and violations are occurring in Guatemala while the profits flow out of the country. But they're Canadian problems, not just Guatemalan problems. It is Canadian impunity, it is Canadian corruption, it is Canadian mining violence, etc. And so in conclusion, I see Testimonio as one more tool of education, and then tool of education that aims at sort of education and activism in sort of 5 main areas. One is we need to really challenge and hold the Canadian government accountable for its policies and actions that promote this, while turning a blind eye to or ignoring all the harms and violations. It's a tool of activism to hold Canadian companies accountable for the fact that they are directly involved in committing the harms and violations and benefiting from them. It's a tool of activism to hold our pension funds and private equity funds and just about every investment fund you can shake a stick at in Canada that are heavily invested in the extractive industry, including mining, while turning a blind eye to the types of things that are set out in Testimonio. This book presents yet one more challenge to the mainstream media. And though there are some interesting and very important exceptions to what I'm about to say, as a general rule, the Canadian media does not give the Canadian extractive industry the necessary coverage, given the breadth and depth of these types of problems that are going on around the world. And I echo Jeffrey Weber's comments about Mining Watch and the importance of the group Mining Watch Canada. There's sort of a clearinghouse for so much important information about these types of issues happening in many countries around the world. And then finally, this book becomes an activist tool and a challenge to what is fundamentally Canadian impunity. Our government, our elites, our government and our elites, our economic elites are intentionally keeping in place impunity, i.e. immunity from liability. While there are a few exceptions in recent history that are before the courts now, on the civil law side of the equation, I think those exceptions prove the rule of impunity. And on the criminal law side of the matter, we don't have any cases at all that I know of where our courts are going to be used to investigate the criminal behavior of Canadian companies in places like Guatemala. So hopefully Testimonio becomes one more tool to be used for these goals and interests. Thank you.
Thank you very much, both Catherine and Grahame, for giving voice to Indigenous leaders and community members who've been directly impacted by the human rights violations and the violence that has occurred. And thank you for being these specific examples of the structural issues that Jeffrey had outlined in his work. And it speaks to the importance of the information you're sharing And the fact that your book was not going to be published shows how important it is that the information is published, and it can be another avenue for people to learn about what's happening, to have some changes made, some fundamental changes made. I'm noticing the time, and I do have questions, but I will defer my questions to the end if David or the audience member has questions. So if there's anybody who would like to ask now, Grahame a question, we can do that. Or David, if you have a question that you'd like to have addressed now.
Well, maybe just a quick one. I list Graham's those final 5 recommendations, and thank you very much, Catherine and Grahame, for this. And you know, the whole, as was alluded, the whole saga of this, you know, let's call it for what it was. It's sort of almost like a slap censorship, right? A strategic lawsuit against public participation censorship, in the sense that, you know, you managed to get your book published, really brought, you know, happily that brought attention to it. But Grahame mentioned of those 5 recommendations, funds, right? Pension funds. And, you know, I mentioned, like, we have something with the International Solidarity Fund, and you also mentioned the work that Human Rights Watch is, sorry, not Human Rights Watch, Rights Watch is doing, to be careful here, Rights Watch is doing with its support to activism, right? But okay, so those are sort of proactive, you know, small funds, relatively speaking. I mean, our Human Rights International Solidarity Fund is like 50,000 or 60,000, right? It's very small. But the real influence here, just like it has been the target of activists in oil, is or are the big pooled funds, right? So pension funds, CPP, you know, including our own academic pension funds and so on, but investment funds from banks, all of those kinds of things. So using disinvestment from oil as a, could we use disinvestment in oil and gas campaigns, i.e. hydrocarbons or GHG producing investments, could we use that model for a mining campaign, a disinvestment in mining, or, you know, something calling for ethical screening, etc.?
Want to go for it, Grahame?
I'll go for it and see what you might add. Just picking up on that sort of list of 5 things, I should sort of preface it and say that I think that underlying all of that, or overriding all of that, is what I think, I'm not going to put words into Jeffrey's mouth, but something I think he might agree with, is that before and after all of what we're talking about, there has to be a fundamental criticism of the globalist capitalist, the global neoliberal model, whatever you want to call it, in and of itself. The types of stuff that we're involved with that are listed there have to do with really challenging the nation state system and the global economic model as it's functioning now, but as it's functioning now without really questioning the kind of stuff that I think Jeffrey is most correctly putting his finger at. But we have to do both things at the same time, because these are real life struggles going on right now. So a book like Testimonio doesn't go into the great depths of critiquing the history and the ongoing model itself, though it's in there. It's really saying, even with the model that we have, look at the hypocrisy, look at the double standard, look at all of the things that are going wrong in the model itself. And so the investment side of things is just one important aspect of it. And it's a real eye-opening side of it, because you bring a story like this home to Canadian audiences and say, oh, and by the way, did you know your pension fund, your trust fund, your school's endowment, your whatever, your private, is invested in this. So you're literally making profits from it as we sit here and listen. That's a really eye-opening and important educational tool that leads through to what to do about it. And so briefly, I think divestment campaigns are sometimes quite useful short-term strategies, because they get to shine a light on a particular case. But the long-term goal is not just, you know, to pick up on what Jeffrey was referring to, bad apples. It's not a question of bad apples. even though you might use a certain strategy at a certain campaign to sully the name of a company and make some headway. Really, a divestment strategy is not the final solution one's looking for. One is looking for structural systemic change in the model itself. So I'll leave my comment about divestment strategies because I do think they can be useful in certain situations. But at a bare minimum, on the investment funds, we need binding laws. We need enforceable laws concerning, can you invest in and make profit from a human rights violating company? Can you invest in and make profits from the military industry that is producing weapons that get sold across the planet? Can you invest in and make profits from the oil and gas industry? All of that is absolutely legal for our pension funds, private funds, et cetera. And it's not just a Canadian problem, it's a global investment problem. So that it's not like those are the only starting points, but they become obvious points of activist concern, and I merit a lot more attention.
Thank you.
I think in the interest of time, I'll jump in later on so that we can get to our next speaker.
Thanks so much, Catherine. I appreciate that. There's so many questions I want to ask, and I'm holding myself back as well. So I appreciate that. Okay, I would like to now turn to the next segment of our speakers event tonight, the mining industry in Canada, specifically in BC. So for nearly 200 years since the colonial mining free-for-all of the mid-1800s, Indigenous people across what is now BC have had their rights disrespected, their lands degraded, the rivers and lakes poisoned, and little has changed since then. Favorable government policy has allowed the mining industry to continue to disregard the safety of Indigenous and non-Indigenous people and the environment in which they live. The current BC mining laws and industry standards fall short of emerging global standards for sustainable mining centered on respect for human rights and the protection of communities and the environment. Business as usual approach has been compounded by the government's continued neglect of Indigenous people's rights nearly 2 years after passing the Declaration on the Rights of Indigenous Peoples Act, which was meant to advance a path forward to true reconciliation, uphold Indigenous rights, and create stronger communities, stable jobs, and economic growth. Virtually nothing has been done to implement it without a voice, and key decisions about mining, such as taking, requiring full bonding at mines, and the creation of mining-free zones, Indigenous peoples in other communities impacted by new and existing mines remain at risk. I'm going to turn over our discussion now to Merle Alexander, who will be able to talk about all of these issues in much more eloquently and in depth. Merle, please.
Well, Lisa, I thought we were going to be the uplifting part with that introduction, and it doesn't sound so great here in British Columbia, does it? Anyways, sorry everyone. Merle, just add a little levity since people are probably getting hungry here at dinner time. It's Merle Alexander. My traditional name is Lachachnitz. I'm from the community of Kitasukakes, which is the big house you see behind me. I'm not there. I'm actually joining you from the unceded tidal territories of the Kwantlen and Wasanich peoples here in beautiful Victoria. I'm going to jump right into my presentation since I know I have to sort of fly through it, so there can be some more time for questions at the end. Yeah, as Lisa has explained, I'm going to talk a bit more about British Columbia, and then perhaps her introduction actually helps me to skip some of my initial slides, which is in some respects not to give like too much of a sunny picture of how Canadian mining companies are operating in British Columbia. So I'm going to first talk about the impacts of the BC mining regime, then the existing legislative framework with the Mineral Tenure Act and the Mines Act, then move on to BC's obligation to protect human rights, and then finally, and hopefully we get a little more time to talk about that, what the potential for dramatic change that the BC's adoption, or BC's passing of the UNDRIP implementation legislation, that is the Declaration of the Rights of Indigenous Peoples Act, which also is to be combined with the federal passing of UNDRIP, with the UN Declaration of Rights of Indigenous Peoples Act. So there's both. BC stands alone as the only jurisdiction in Canada where both federal and provincial commitments to implement UNDRIP are both in place, both of them also at their infancy. So I will jump into the presentation. So I mean, I don't think it's there's any shocking or positive news really necessarily when you take a look at the way that the BC mining regime has impacted Indigenous people here in British Columbia. I think a very helpful sort of summary of the BC mining law reform network showed that there was many examples of the destruction and damaging effects of mines here in British Columbia. Some of the examples that come to mind that are highlighted in the presentation here are the Elk Valley coal mines, where a recent $60 million fine for selenium and calcite contamination was recently issued. A still operating Copper Mountain mine, which never underwent an environmental assessment, and to this day, discharges 60 liters per second of treated wastewater into the Silkameen River. Britannia mine, as it is in the first point there, resulted in a 46 million bill to taxpayers, plus an annual bill of 3 million for water treatment in perpetuity. So very much in British Columbia, the damages and the reclamation that occurs in Indigenous territories throughout British Columbia are, for the most part, still picked up at the expense of the destruction of territories and also the taxpayer bill in British Columbia. It still is very much the case in British Columbia that there's been very minimal mining law reform from a fairly antiquated sort of model that's mostly driven from the 1800s. A very recent example that is connected to ongoing legislation or ongoing litigation is the Gikakla, the Banks Island gold mine, where the Gikakla voiced their worries about a mine and the impact of its environment review of the project. After the province didn't actually do any substantive inspections until it was brought to the attention by employees. A day after the inspection, a pollution abatement order was issued saying that the mining company had released tailings and effluent into the creek, lake, pond, as well as forest and wetland on Banks Island, and that had created a profound environmental damage as a result. So there's a quote there that's by Chief Phil of the Gikakla First Nation that puts it pretty succinctly that their people were unable to harvest food in that area because of the tailings discharge into the ocean and right of the harvest beds. I mean, it gives you a very even just that mere example gives you an idea of how the mining regime in British Columbia has a capacity to deny constitutionally protected rights. I mean, quite clearly, the Gikakla have the right to harvest fish, harvest salmon and many of the other species, and they're denied that, if not have it taken away by the poor mismanagement of the environment by the existing provincial regime. Part of that really key aspect is almost just from day one in BC, the way that the mining regime works. I mean, the Mineral Tenure Act has attracted a substantial amount of very easy criticism, and that the only modernized aspect of the Mineral Tenure Act is the ability of somebody essentially with a credit card being able to gain significant access rights to a territory. So if you only had it, there's been lots of different sort of like demonstrations of this, but literally all that one would need is a credit card to then go on to the online Mineral Tenure Act system, select the territory, enter your credit card information, and within minutes, you would have a substantial interest in the capacity to potentially to stake within any given First Nations territory in the province. I think, like, on the face of it, it's just glaringly obvious that that does not fulfill the BC government's legal obligation to fulfill a duty to consult. Because before even anyone who's any sort of like any individual or company can already gain a substantial interest in a First Nations territory to stake before anyone's been notified. And it's only really after the fact, it's what you end up with sort of is after the fact post consultation. And the Mines Act actually almost works in concert with a very similar regime, both of them very archaic, which allows a fairly significant amount of like trenching and digging holes in a territory, as long as it's kept under a certain threshold. All of this without substantial consultation ever fulfilled between the First Nation by the Crown or First Nation or the proponent. So I think, like, of particular concern, I think, to Indigenous peoples are the provisions that allow for the mineral plastic to be registered with really no notification, no involvement of Indigenous peoples, no environmental assessments, no weight on protected areas. And these provisions like completely fail to recognize Indigenous interests. So that's in a sort of a nutshell, sort of like what's wrong. That's actually led to Gakakla very recently in the last 6 months, filing litigation against the governor of British Columbia to particularly on Bank Island, that sort of like that is going to challenge and potentially turn the entire mineral tenure regime on its head. One, they're sort of making that very clear argument that the automatic registry system is inconsistent with the constitutional honor of the Crown to follow the principle which gives rise to the duty to consult and accommodate. That, on the face of it, just seems like a plain and simple argument. Another interesting alternative argument they are making is that Indigenous peoples are being automatically dispossessed of their title and rights without constitutional consultation or notice, which violates the BC's Declaration of Rights of Indigenous Peoples Act. So all of this like mineral tenure activity that's happened in the Gakatlas territory has happened within sort of this advent of legislation that's supposed to dramatically change the regime from a consultation to a consent-based framework. And clearly, I think on the face of it, both the duty to consult and any new obligations are sort of parallel obligations that are created under the Declaration of Rights of Indigenous People are both being violated. And a different way of sort of looking at it is that BC is breaking their own Declaration of Rights of Indigenous Peoples Act. That litigation has just sort of commenced, and there is quite a long list of interveners that are getting involved, because obviously this exact same scenario is playing itself out throughout British Columbia. So it'll be interesting to see whether or not that will be an impetus for potential legal reform. So obviously, like, I guess I don't really need so much to talk about this. I mean, with the passage of the Declaration on the Rights of Indigenous Peoples Act in November 2020 or 2019, now almost, I guess, two years and 3 or 4 months now, there is a substantial commitment to implement UNDRIP in British Columbia and to make all BC laws consistent. I'll move to that part. Presentation. Like one of the there's 3 main core elements of the new Declaration and Rights of Indigenous Peoples Act. One is the requirement to make all BC laws consistent with UNDRIP. 2 is a requirement to co-develop an action plan with Indigenous peoples in British Columbia. And 3, there are enabling provisions that allow for consent-based decision-making agreements to be negotiated. The nuance of that last portion is that the BC government does enter into sort of into government-to-government agreements on mining, but most of those agreements are much more consultation-based, and language such as cooperative management, joint decision-making, shared decision-making had sort of hit a bit of a glass ceiling, whereas like Indigenous groups have been pushing, or First Nations have been pushing towards like much more consent-based like framework or co-jurisdiction framework. Until these enabling provisions of DRIPA existed, there was no legal mandate or no legal enabling provision in the statute that would allow for consent-based decision-making, and that was sort of in some respects the argument against it, or at least the way that the provincial government resisted it to date. Now with this new particular Section 6 and Section 7 of DRIPA, there is the ability for the BC government to enter into consent-based government-to-government agreements. So as a bit of sort of a highlighted sort of like state of progress, the first provision to make the requirement to make all BC laws consistent with UNDRIP has actually changed dramatically the way that laws are developed in British Columbia. So basically any single statute or regulation that is potentially to be introduced into the BC legislature has to now go through a consultation and cooperation process with Indigenous governing bodies. That, you know, how it's determined who is an Indigenous governing body, that is still very much a sort of the beginnings of a project, because there is not like there's not a single organization that is delegated the legal rights to represent all rights holders. So in theory, that mechanism still has, or not, sorry, in theory, that mechanism of how rights holders are going to have their say in the development of legislation still has to be developed. In the interim, the representative organizations of the First Nations Summit, Union of BC Indian Chiefs, and the BC Assembly First Nations are in an ad hoc manner sort of playing sort of a temporary role to sort of facilitate that consultation cooperation role. That and a whole bunch of different other group of First Nations that either have modern day treaties or have very advanced reconciliation agreements that also require them to be involved in statutory changes. So basically the entire the way legislation is being developed in British Columbia has started to dramatically shift, and that every single time a new bill that may be inconsistent, might have elements of consistency with UNDRIP, is potentially going to be introduced into the legislature, there is a consultation cooperation process. To date, that process has probably been, it's a bit of a tension between a colonial approach to secrecy, which most legislation is developed within, to the movement towards a much more co-development or co-drafting regime. And right now, at least in the first couple of years of implementation, there's been more bureaucratic resistance to sort of opening up and changing the legislative process. I think that as legislation is, as time goes on, and as there is a mechanism developed with much more sophistication for allowing rights holders to have their say, that the process will become a lot more consistent with the legislation. Right now, it's sort of we're in sort of a transitionary period where I would say the process has been more superficial. Also, most of the time, the legislation is already fully developed before a consultation and cooperation element sort of comes on. So it's not really free prior. It's just more, you know, in sort of it's like partially informed. It's partially informed consultation as opposed to free prior informed consent. So that I think that process is sort of very much sort of at its infancy. In terms of legislation that's in the queue, that's in some respects relevant to the mining regime, the Protected Areas of BC Amendment Act is being introduced for this legislative session. The Skills Trade BC Act has some application. There may be some application of the Anti-Racism Data Collection Act. And to the extent that there's some interaction with forestry related issues, there's some amendments around the Forestry Range Practices Act. The Wildlife Act is being amended, and there's a possibility that there may actually be a Section 7 of DRIPA Consequential Amendment Act. So there are a lot of things actually even in this particular legislative session that actually is quite a long session. It started in February and extends to June. So there's a number of pieces of legislation which actually are potentially have exploration mining applications to it. In terms of future sessions, the Forestry Act and particularly the Mineral Tenure Act has been identified for potential legal reform. So I'll touch a little bit more on that. The action, like one of the core elements of DRIPA is a requirement to develop an action plan. So that action plan is supposed to be all the potential legal reform and legal change that may occur in the next 5 years that to implement UNDRIP. So the very first action plan was tabled in June 2021. There was a consultative period that ended around September 2015, and it's expected that the first action plan that will be released will be March 31st. I could say that there's quite a bit of optimism and confidence that the mineral tenure reform will be one of the core elements of the action plan. So that will make, like, for all that we're sort of saying is wrong with the current mining regime, has the possibility of going through a very substantial consultation and cooperation process to co-develop new legislation in this area. When you combine that with the fact that the environmental assessment, the BC Environmental Assessment Act itself is also shifting to a much more consensus to consent-based process, there could be a substantial sort of empowering uplifting, I think, for the ability for Indigenous people to affect major projects, including mines in their territories. A pretty concrete indication that there is relatively good reason for that hope is that the very first Section 7, that consent-based government-to-government agreement that's been identified was identified last June, and now seems to be fairly close to its they're getting, as far as I understand, they're getting very close to a final document, is a negotiation between the BC government and the Tahltan central government, which is sort of quite a hub for exploration and mining activity. The very first Section 7 agreement is to negotiate specific to 2 mining projects, particularly a consent-based framework for those 2 particular mining projects. So if that model is to be sort of replicated throughout the province, we could be starting to see a much more dramatic shift to modernize BC mining legislation towards a much more sort of consent-based framework. I think what's like very almost easily apparent is that the current legislative regime doesn't even meet the duty to consult, let alone the aspirational or the more concrete legal obligations that free prior informed consent may bring. So something else that it's not covered in the presentation, which I think is relevant, is that in all of the, I mean, obviously, like they're like with the way Indigenous or like primarily First Nations engage mining proponents, is most of the process. There's like a government to government element to it, but then there's a First Nation to proponent relationship, which is usually negotiated throughout in an impact benefit agreement. When you take into consideration that there does seem to be a pretty predictable shift from consultation to consent, there are First Nations that are in like good position to sort of start renegotiating their impact benefit agreements to create that shift from consultation to consent. And evidence of that is that the Kamloops and Skitchison First Nations just recently announced that they have successfully negotiated a free prior informed consent-based agreement with New Gold. So I think, you know, that there is reason for I think for some positive optimism. I do also think, though, that there is a broad spectrum of First Nations even within British Columbia, in the sense that there are some First Nations that are greater in power to sort of be able to advance consent, and those that have less capacity end up getting sort of lower level consultation, because capacity dollars and things of that sort actually have a significant bearing on their ability to negotiate and leverage their rights. But with that said, I think I'll end my part of the presentation there so we can leave some time for questions. Thank you.
Great, thank you so much, Merle. I really appreciate that, and thank you for putting in the positive aspect. I always like to end off on a positive note. So we definitely do seem that there's more, at least hopeful aspects of it. That it's exciting that the legal case that's coming up challenging the Mineral Tenure Act on duty to consult and the legislation of the BC DRIPA. So that will be really exciting to watch and see what happens, and the legislative changes underway for the Mineral Tenure Act on the particularly the one about the credit card and being able to essentially buy interest in land in BC. When I first became aware of that, I was just amazingly shocked and had no idea that it was so easy to acquire type of interest like that. So hopefully that will be addressed soon. I do want to ask the audience first if they have any questions for Merle before our moderators. There was a thought by Adam, and I wasn't sure if it was for Merle or not. I think youth voices hold a unique power as university provides a platform for a movement to be widespread. How would you catch the majority students' attention? Which type of project would you want to see students initiate? Was that for Merle or was that for somebody else, Adam? While we're waiting for Adam, I'm going to turn to the questions I have for Micah. Thanks, Merle, for this thoughtful and hopeful summary. I wonder if you could speak more about enforcement and the role of the province or feds in enforcing the agreements obtained by mining companies during the consultative process after the permits and licenses are issued. Merle, are you able to speak to those issues for Micah?
Yeah, I mean, if you're talking about the impact benefit agreements, which I think is what you're probably, I mean, so far there are not any federal like government to government agreements on specific projects. So there's probably not much to talk about in enforcement on a federal level, but there of course are a style of agreement entered into, like a government to government style entered into between BC and First Nations on specific mining projects. Those are called Economic Community Development Agreements, or ECDAs. I mean, the reality is that those ECTA or those agreements are really only about financial accommodation. They allow for the 37.5% sharing of the mineral tax, but they don't really. It's really money. Basically, they're actually quite. It's quite an impoverished view of like what actually consultation should actually fulfill, because it's really like money in exchange, like mineral tax, like revenue sharing in exchange for the entirety of the fulfillment of duty to consult, which is obviously a pretty impoverished like look at that. I mean, they are enforceable, but to date, I don't know that there's ever been any case law that's actually sort of like gone into the elements of trying to enforce an ECTA. I guess the only reason that would ever occur would be if the First Nation decided to terminate the agreement, or if the government didn't pay, because there isn't really much to the substantiveness of the agreements. I mean, it is progressive in the sense that like BC is one of the few is the only province that's actually doing a substantial like revenue sharing with like on mineral on in the mining context, but it's not a dramatically like it certainly isn't like free, prior, informed consent, and doesn't really speak to the governance elements of it. If you're talking about impact benefit agreements, similarly, I mean, the only real place to enforce an impact benefit agreement would be to take those agreements to court. And to my knowledge, the courts have only had a couple instances taking a look at even the content of impact benefit agreements and never had to enforce them. I mean, I think mostly what is maintaining the enforceability of impact benefit agreements in British Columbia and Canada is the legal uncertainty that might be brought to bear by First Nations like taking the mining proponent to court. I think that is a unique aspect that I think that Canadian First Nations or Canadian Indigenous people have, is their ability to access, you know, their capacity to access the courts can create a dramatic legal uncertainty about the viability of a project. And I think we probably all know that like exploration mining investors are quick to move their money if they feel like there's not like it's not a legally stable investment. So that vulnerability of being dragged to the courts and being dragged, like the projects being dragged, like being made potentially legally unstable, or the legal certainty of the project in itself has been, for the most part, I think, incentive enough. So the courts, I think the enforceability elements are mostly sort of set out in the content of the IBAs itself, but not in and there's been few judicial considerations of it. So at least that's, to my knowledge, like what this current state is.
Thank you, Merle. There's a question from my colleague at Kwantlen Faculty Association, Sima Alawalia, who's given some background about Article 46 of UNDRIP, and she quotes from that and says that important passages were removed. You can refer to it in the chat. Important passages were removed from the draft of UNDRIP that was worked on for decades. This is presumably in the consultation for developing UNDRIP, that changed the intent of the declaration by privileging the power and jurisdiction of nation states over the rights of Indigenous people. So why are we trying to enforce UNDRIP, right? And I've heard this argument by sort of this debate by a number of scholars, like why use a human rights, why try to impose this human rights regime that is already flawed in the eyes of some folks?
I mean, obviously, UNDRIP is a international instrument negotiated between states. So, I mean, although there is obviously it's probably the most involved international instrument, like the Indigenous peoples themselves participated in the negotiations like firsthand. I mean, in the end, it is still an internet, like it's an instrument of sovereigns, and to date, obviously, like the final language of Article 46 wasn't preferential. I think, you know, I think it's too early. Like, I think for people to it's too early in the implementation, and it's also I think there's a significant underestimating of the advocacy of Canadian Indigenous peoples to create dramatic advocacy for their rights. So I mean, yeah, UNDRIP has its limitations, but it's only like one legal instrument that Indigenous peoples in Canada will use to advocate for their rights. Like Canadian Indigenous peoples particularly have like a pretty fierce like toolbox or like arsenal of weapons to bring to bear on any specific proponent. So I mean, UNDRIP isn't going to be like the only legal tool. And also Article 46 will be interpreted within the Canadian context. So at minimum, it's going to have to interact with the entire body of Canadian common law around Section 35. So you have to read it, I think, consistent with like the justification analysis that the Canadian courts have developed around infringing Aboriginal rights. I think you need to sort of have a better sense of the way that self-governance coexists between provincial, federal, territorial, and Indigenous governments. I don't think that Article 46 is an argument against implementing it. It's just one of the it creates a challenge. But I mean, as an Indigenous advocate and who works for some pretty extraordinary Indigenous leadership, I don't think that they're going to shy away from like false interpretations of Article 46. It's more a matter of taking that fight to the next level, and that next sort of like arena is the implementation of UNDRIP. So it will be statute by statute that these issues around Article 46 may or may not come into interplay.
Thanks.
Thank you, Merle. I actually have a question I was hoping to squeeze in before it was over. This goes either for Jeffrey or Catherine or Grahame. As it was talked about, mining companies are extracting billions of dollars worth of minerals every year, but they're only paying a tiny fraction in taxes and royalties compared to other operations in countries. And Jeffrey, you spoke about the benefits of mining, the employment, et cetera, and versus the negative, and the benefits are quite negligible compared to other industries. And Grahame spoke about that as well. I'm just curious of why, because when I heard, when I first understood that, Canadian mining companies were the most prolific in the world, and then it's in large part due to these tax, essentially almost havens that Canada offers for mining companies. What is the benefit to Canada for offering such lucrative benefits to mining companies, particularly if the other sort of benefits of mining, jobs is often focused as one option, is really not there. So what is Canada as a state, as a government, as a country, what are they getting out of it? Even putting aside the human rights issues, I mean, obviously, this is a huge thing that's going to overcome the benefits, but it doesn't seem like there's a lot of benefits even as is. And I'm just curious, do you understand the rationale for the Canadian government to offer such a benefit like this?
Jeffrey, you want to start on that?
Sure, I can give it a shot. I mean, there's a short answer and then a longer one. The short answer is, I think the search, your search and the question for what are the benefits will be a long search, right? In the sense that there are no benefits to let's say to the Canadian population of Canadian, but there are benefits to governments in the sense that both the Liberal and Conservative governments have been interested in and have long been parties of capital. So it makes sense that they would in office legislate on behalf of securing the juridical regimes here and abroad that allow for optimal profitability above all else. So on that score, they're doing very well, right? If that is your metric, then there are all kinds of benefits. So the benefits are, for example, a massively dynamic Toronto Stock Exchange, a massively dynamic Toronto Venture, and which the media happily reports as major successes for Canada. But of course, we ought not to confuse Canada with Canadian mining capital and Canadian interests abroad, as the Canadian state understands it, is more or less synonymous with the interests of Canadian capital abroad. So I don't think so. For example, in the pensions, in workers' pensions and unions' pensions that are investing in these dynamics, it's of course a complicated question, because of course workers in Canada, we need to defend the notion that you have the right to a humane retirement, right? The problem is a structural one of privatizing pensions so that it's even possible to pursue this, that the way that you can live a life which is dignified in retirement is based on private accumulation strategies by union bureaucracies. And it's hardly the case that unions in Canada, by and large, are massively democratic internally, right? I'm very in favor of unions. This is not my point, but my point is that if we were responding to the rank and file members, most of whom have no idea that their pensions are being invested in the dispossession of Indigenous people in Guatemala, then we might be in a better position to steer things in a different direction. But my basic point, I'm going on too long here. My basic point is that the reason why Canadian governments do this is because they're run by parties that are business parties, and so they're functioning exactly as they were intended to do.
I'll just jump in and make one small point as an illustration of exactly that. So recently, the Justice and Accountability Project out of York University, with several lawyers connected with the center there, detailed through access to information documents the way in which the Canadian government, as Jeffrey said, through embassies, through all sorts of people connected with the Canadian government, or embassies and so on, took hold the experience of Goldcorp and their approach to not having to close down the mine when directed to by the Inter-American Commission of Human Rights. And they didn't seek out, as they're obliged to do, to focus and support issues of human rights. They didn't pay attention to anything anybody was saying to them besides what the argument of Goldcorp was, that nothing was wrong and they should be entitled to stay open and continue mining gold. And through that documentary evidence, through access to information records, we see how the Canadian state did everything possible to ensure that the interests of Goldcorp were at the forefront, and the order to close down while concerns around all these violations were taking place, that was lifted. And there's a very clear record of that now. We always knew that was probably the story, but the more we do these, it's very hard to get much information with access to information requests and so on. But some of the, somebody else had asked about lawsuits. There are very few lawsuits, but through some of those lawsuits, through the discovery stage, documents are made available of corporate communication that would never be found otherwise. You wouldn't get those through access to information requests. And those are quite damning, right? And the communications between the Canadian government and so on with the companies and then those on the ground who, make things happen, like dispossession of people from the land is on record now. So as Jeffrey said, there's a real reason why it's happening. Lots of people are making money. And really what we've been able to see is doing it at almost all costs, never thinking that people would dig too deep into it.
Lisa, I would just jump in on these comments and say, pick up the notion that's been shared, not today necessarily, but often in these types of discussions, the sort of the economic model and the race to the bottom. And so I do think that I share Jeffrey's comments, like if one mentions the pension funds, there's a direct benefit to global investors. It's not just to the Canadian state, like taxes paid to the Canadian state, but there's a direct benefit to Canadian investors, the shareholders, the pension funds, the investors, etc. And then I agree that that's not benefiting all Canadians equally, but we have a very unequal economic model within our borders. And these models are very much the global development economic model, which I do call in many countries around the world, like Guatemala, as a race to the bottom model, benefits certain wealthy, powerful interests. And dominant political parties in Canada represent those interests. And everyone knows about, and our book documents part of this, but Mining Watch has documented the revolving door between the mining industry itself and top Canadian political parties, particularly the Liberals and the Conservatives. And so the race to the bottom, I think, is part of the answer to your question. I hope it's helpful. In Guatemala alone, we could write a book like Testimonio about the banana industry, the coffee industry, the African palm production industry, the sugarcane industry, the maquiladora sweatshop industry, all of the above. And every one of them is a race to the bottom model. Who are the major beneficiaries? Clearly the shareholders, the companies, and their colleagues in the wealthier sectors of the Guatemalan society or the Canadian society or the American society, wherever these companies and investors are based. But there's always that trickle-down benefit because it's producing more and more products for consumption at lower costs. So if you took the maquiladora sweatshop industry, we could go on for hours about who wins and who loses from the sweatshop industry itself. Most of the benefits accrue to the owners, the investors, and the shareholders and their colleagues in the political sectors. But some benefits accrue to the production of cheap products that then flood the global markets. And the global markets are mainly the markets in the wealthier, rich nations of the planet. I think this might be part of the answer to your question. I hope it's helpful.
Yes, thank you very much. I know it's much larger issues involved. I am noticing the time. I'd love to engage more with everybody. I'd like to thank everybody for participating in this panel. Jeffrey, Grahame, Catherine, Merle. It was so fantastic that you were all able to join us. I hope, ending on a slightly positive note, I know I teach human rights, and every time I get to the end of the semester, I think, oh, I've got to end on more positive note instead of just bringing up all these issues. And so I hope that the gains made in the courts and the Garcia and Tahoe case, where the British Columbia Court of Appeal recognized that they wouldn't get a fair trial in their own country and could have their case here. The Supreme Court of Canada, including the concluding international law, forms part of Canadian law. And the fact that Merle spoke about Indigenous people having partial past consent and now getting more free and informed prior consent, work in that pathways. We're making some gains towards at least where we're trying to be. So I leave on hopefully a more positive note that there's more to be done, and this speaker series is one aspect of getting more to be done, making people aware of what is happening and highlighting the issues that need to be addressed. So thank you all for joining us. I appreciate your time and your energy and your efforts. Thank you very much.
Thank you. Thanks for everything. Thanks, everyone.
Thank you.
Thanks to all the wonderful the wonderful work also from our colleagues with FPSE BC, particularly Elisa Navari and Nicole Seguin. I mentioned their names in the chat. Thanks to my co-moderator, Lisa David from Douglas, and appreciate your work. And also our chair, Alexandra Phillips. And there was a question from one of the students. I think some of it was answered in the chat. There's some resources there in the chat. So, youth energy is really important, particularly on Indigenous rights, on reconciliation, and on what's happening abroad as well. So stay tuned, because FPSE in the coming year, we're hoping to do another session on international students as well. So that link becomes so important. Thanks once again.